Kenya's President William Ruto has signed into law a bill that aims to tackle illicit financial flows from the East African country. Now, this law is looking to seal critical gaps that have enabled money laundering through property transactions, for example, but also the use of shell companies whose beneficial owners are not 100% clear. It's also aimed at dealing with terrorism financing and proliferation. Now, in 2024, Kenya was grey-listed by the Financial Action Task Force, better known as FATF, at least in these circles, due to the lack of a clear strategy on the prosecution of money laundering offences and effective prosecution of the same. The government now hopes that this new law will help to address the watchdog's concerns and streamline financial flows in the country. Let's bring in Churchill Ogutu. He's an economist at IC Group to explore exactly what the implications of not just that law, but also being added to the list of high-risk jurisdictions by the European Union are. Churchill, welcome to the program. So from the perspective of, say, a medium-sized enterprise here that might be exporting horticultural products, flowers, vegetables, for example, into the EU, or someone who gets remittances from a country in the European Union, how will Kenya being added to this list of high-risk jurisdictions change how they receive their payments or do their transactions?
Thanks, Rama, for having me. So if you look at the broader picture, what you've spoken about, the Financial Action Task Force, which essentially puts a country into higher monitoring, and then where the EU is coming from, basically being part of the wider Financial Action Task Force, they have also sort of followed what the Financial Action Task Force is talking about, and hence this high-risk jurisdiction status that is being put on Kenya. And the implication of that on the SMEs who are into largely the horticultural sector, which is quite large between Kenya and Europe, we are likely to see that the cost of the payments or the cost of doing business will likely skyrocket slightly higher as the companies just get into compliance with the EU regulations. And in attendant to that, remittances also from Europe is not as massive as what you are seeing from North America or even the Middle East. But nonetheless, it's something that comes as remittances. Might also be, we could likely to see some high cost of compliance in terms of remittance flow from Europe to Kenya. And in light of that, and also in attendant to that, we are seeing that Kenya is within a more volatile region. We have some of the neighboring countries which are housed, they are not citizens in Kenya, but largely they get the remittances from Europe, but into Kenya. So I think that is also the thing that has been flagged by FATFA, and that might also increase even the cost of doing businesses from a corporate perspective, and also the unilateral payments via remittances.
Let's focus on what FATF said, because reading that report really was pretty fascinating. It makes for interesting reading. And one of the things that they pointed out is that between 2019 and 2021, the government pursued a very small number of cases where public funds were stolen and then the proceeds were moved outside the country. Now, clearly there were laws in place, right, to deal with this sort of thing. So is the issue here a lack of laws to deal with money laundering or the enforcement of those laws?
Yeah, absolutely. There's been a raft of laws to tackle this kind of corruption that we've been seeing. So it's not that we don't have the necessary laws. The laws are there, but it all boils down to two things: enforcement of those laws and also the political goodwill. And a case in point, ever since the grey listing that came in place February last year, we have seen close to 14 recommendations, so some form of some upgrade of sorts into the initial list that was there as of February 2024. We even seen the Cabinet Secretary of National Treasury at that point even coming up with some additional laws to strengthen this kind of anti-money laundering. So it is not the laws that is an issue, but it's now the enforcement and the political goodwill. If you look at even the companies law generally, and attendant to that, there's what we call the beneficial ownership, which regulations, which is now at least coming in to address the issues that you've raised, that we can now be able to see the beneficial ownership, be it the contracts in the public sector, or even some of the big ticket in the private sector. But that hasn't been forthcoming, or it hasn't gone as per the regulations. So it's the enforcement of the law and also the political goodwill, which is now the Achilles heel if you talk about tackling anti-money laundering in Kenya.
Indeed, and to just cite some of the things we hear from observers, one of the arguments is, if you can't prosecute policemen who are shooting civilians in the street, how will you then be able to actually deal with money laundering issues decisively? One last question for you, Churchill. So one of the things the Financial Action Task Force also pointed out last February was that Kenya was greylisted because there's a lot of use of virtual assets, stablecoins, cryptocurrencies, but there's no legislation right around the regulation, the question of whether or not hosting them is legal and so on and so forth. Is that deficiency what the Virtual Assets Service Provider Bill is trying to cure?
Yes, so evidently that particular recommendation that Kenya needs to ramp up its legislation around virtual asset service providers was one of the 8 action points that Kenya needed to implement. And that we've seen as of in the course of last year up until right now, we've seen the national policy around virtual assets coming into play. And also we've seen the first draft virtual asset service providers bill coming in place last year. And also it was reintroduced again in March this year. And this is the bill that has been enacted into law. So this bill now speaks to a legal framework around the licensing and also bringing in place these virtual asset providers. And it also, on a regulatory perspective, we are seeing the likes of the Central Bank of Kenya now handling the virtual asset wallets, and also from the CMA, because there's a number of products, be it tokens, be it also these NFTs or what, which are considered virtual assets. Now, this will be under the purview of the Capital Markets Association, which now tackles around the capital markets products. So it's on the regulation, just to have an overview as to how the players within this ecosystem will be regulated. Also, they have introduced a number of penalties, a rate for individuals around $23,000, corporates around $77,000 for any of the entities or individuals who might flout these particular laws. So it's a good step in the right direction.
Right.
Evidently, may not be able to plug that deficiency, but at least it's a good step in the right direction.